relatively few or no consequences to, to impact on you at the end of the day. So these issues aside, I mean, let's just come to the topic at hand, which is mediation as a means for alternate dispute resolution. I would prefer to call it the appropriate means of dispute resolution rather than alternative, and that I think that's something which we need to keep in mind and make it the first point of contact for most people. The challenge is, how do we do it? How do we create this culture of mediation rather than one which is based around people trying to resolve their disputes through the courts, which has been the traditional methodology. As my colleague Justice Mia Gul Hassan Aurangzeb pointed out, he and I had the benefit of being on an exploratory tour to Turkey organized by the Legal Aid Society. Justice Khilji Arif Hussain had very kindly hosted us on that occasion. And there we got certain insights from the Turkish model as to how they had combated the issue of pendency. They said that at one point in time they were overwhelmed with cases that were running into the millions, and that figure perhaps makes our pendency pale in comparison. But then they said that the legislature over there had, taken serious notice of the situation and made mediation mandatory in certain areas where it felt that it would be conducive, such as labor disputes, consumer protection cases. And that's something which we need to touch upon here because, again, coming back to the CPC, coming back to the system for mediation, at least in the province of Sindh, that has been brought about in the year 2018 through a basic amendment in the CPC. Section 89A has been introduced, certain rules have been added, Order 10 perhaps, and under that framework, you can goad a party towards mediation. You can't really compel or force them. That's also something which the eminent speaker pointed out earlier. But the Sindh High Court is also faced with its peculiar problems. The issue of pendency was something which Justice Jawad had highlighted, and the Sindh High Court, at least on the original side where most of the civil litigation comes up, is particularly impacted and afflicted because of the design of the original jurisdiction of the High Court, as it's so called. So imagine, for example, that Karachi district has a population of 20 million plus individuals, all of their litigation of a certain pecuniary value, now of over 6.5 crores, will originate in the Sindh High Court. What the wisdom of that is, I leave it all to you to reflect on that for yourselves. But we are told that historically the reason for this is that Karachi was a port city and a commercial center, and complex cases of a commercial nature were likely to require the require deliberation by a high court judge. I think that's a somewhat flawed construct in the way that it's now been engineered, because simply saying that a case has a value of over 6.5 crores doesn't necessarily mean that the underlying issues are complex. So what's happened is that the Sindh High Court is awash with litigation, and the judgment which Jawad Saab had earlier referred to was a case where certain lawyers had brought a challenge to this jurisdiction itself. And we had called for the data, and we had seen that as many as 20,000 civil suits are pending on the original side alone. And at best, you can have 4, 5, 6 judges devoted to this side of the court. So, just imagine 6 judges trying to cater to a pendency of 20,000, and you'll realize that it's a losing battle. So mediation is a subject which, I don't claim to have any particular expertise of. I have not been trained as a mediator. I have not actively engaged in too many mediations. But as a judge, as somebody who's invested in the judicial system and has seen the judicial system at close quarters, I can safely say that the judicial system is choked. The Sindh High Court is choked. I think the district judiciary is also choked with cases. And we need to come up with whatever solutions we can that would be practical, that would work, that would serve to alleviate that burden. And I think mediation presents a very vital, flexible sort of tool where the parties need to be sensitized to the prospect of mediation, made aware that mediation will provide them a viable platform. There are many species of cases where perhaps if the state is involved or people who have come forward to litigate for malafide intent, such cases may not be fit for referral to mediation, but at least those cases where there are genuine litigants who have a genuine desire to solve their problems and they find themselves caught in a system afflicted by delay, this prospect of mediation will at least provide them a means of dispute resolution, and I think that could potentially cover to cater to a significant number of cases. At the end of the day, I think one has to realize, and I would just like to share an insight that was, shared with me by an old family friend who is now no more. He was a prominent businessman from Karachi, and he said that his father had told him when he was a child that he should always bear in mind that a bad settlement is more often than not better than a good lawsuit. So, keeping that in mind, I think this is a culture which needs to be inculcated in us as judges, in our, members of the legal fraternity who may perhaps be laboring under some apprehension that if mediation takes over, it will, be to their detriment. I don't think it needs to be viewed that way. The members of the legal profession can play the role of mediation advocates, so they have a positive role to play as well. So the bar councils, the state, the judiciary, litigants, all the stakeholders in the system need to actually to gel and come on the same page, and then hopefully we will be able to move forward. We've lagged behind in this respect by a generation or more perhaps, but it's never too late. So let's remain optimistic and hope that we can achieve and improve our system, provided that we have the intent to do so. Thank you.